Hello everyone and welcome to Uncivil Law. For today's video, I want to clarify a few questions I've seen floating around relating to how Karen Read might be sentenced with respect to various things, how count 2 works functionally, whether the jury can find not guilty on some things in count 2 and hang on others. A lot of questions been circulating around, and I'm going to try to clarify those questions right now. So let's start again with count 2. So as you will recall, there are 3 counts. There's count 1, count 2, and count 3. Count 1 is murder, count 2 is manslaughter, count 3 is leaving the scene of the accident. Count 1 and count 3 are somewhat uncomplicated because there's only one option, guilty or not guilty, right? There's no complication about it. Count 2, however, is complicated because it's got 5 options, guilty and then 4 various guilty options, wherein we've got 4 lesser includeds of count 2. All right, so some people want to know, like, what happens if the jury hangs on some, but not all of count 2? How does that work? So, first of all, what the judge can do. All right, Judge Bev can ask for partial verdicts with respect to count 1, 2, and 3, but she can't ask for partial verdicts within count 2. The case law is fairly clear on this. We've discussed this before in covering other cases. So if the judge were to ask for partial verdicts, she could only ask if they have a verdict with respect to count 1, count 2, or count 3. She can't ask within count 2. That has been deemed by the courts to be unduly prejudicial. So first of all, she doesn't have to ask for partial verdicts about anything, as we've sort of discussed, right? There's no precedent that appears to require her to accept partial verdicts. And so if the jury comes back and says, well, can we deliver partial verdicts? Or if they want to ask about partial verdicts, you know, we might have that discussion at a later time. But if they you know, unless you know the jury says we have partial verdicts, I won't worry about it too much. But they cannot return a partial verdict within count 2. So even if they had like a partial verdict with respect to 1, 2, or 3, like if they had a verdict on 1 and a verdict on 3, but were hung on 2, the question would be like, well, you wouldn't be able to ask which part of 2. You wouldn't be able to ask that question. So the way this form is drafted, like let's suppose a case that might be deemed the best possible case for Karen Read. Let's suppose the jury says not guilty on 1, not guilty on 3. And with respect to count 2, they said not guilty on 2, not guilty on 3, not guilty on 4, but were hung on 5. Right? That's where the jury is, right? They can't do that. They can't do that. And the judge can't ask them about partial verdicts within count 2. So within count 2, it's kind of like they have to check one of these 5 boxes. And if they can't check one of the 5 boxes, right? Because if they check box 1, they're saying not guilty of the offense charged or any lesser offense. So they're saying not guilty across the board, right? They're saying not guilty as to all of them. Well, what if they can't decide? What if they're not guilty as to 2, 3, and 4, but they can't decide as to 5? Well, they can't check box 1 because they can't make up their mind with respect to box 5. They can't check box 2 because they don't think guilty. They can't check box 3 because they don't think guilty. They can't check box 4 because they don't think guilty. And they can't check 5 because they can't make up their mind. So they can't check any of the boxes on this form. And the judge is not permitted by the case law to ask about partial verdicts within count 2. So even if the judge wanted to like ask about partial verdicts with respect to counts 1, 2, and 3, she can't ask within the count. So if the jury said, well, we have a verdict as to some but not all counts, right? And the judge wanted to entertain that, she could say something like, well, if you have a verdict as to count 1, 2, or 3, as the case may be, then check the boxes accordingly and return them. But they can't like subdivide count 2. So count 2 is, if you like, kind of all or nothing. They cannot return a not guilty with respect to part but not all of count 2. That's not a possibility. So if this jury were to find, like in their own heads, not guilty as to 2, not guilty as to 3, and not guilty as to 4, but hung, there's no way for them on this form to express that view. And also, the judge can't ask. So a future jury would be able to reconsider all of count 2, right? Because if they can't make up their mind, if they can't check one of these 5 boxes, then everything is fair game within count 2. So if the judge were to accept partial verdicts, if the jury acquitted as to count 1 and count 3, like they did last time, and if they had some not guilties of count 2, then the judge would enter count 1 and count 3, and the judge would not enter anything with count 2, which would leave manslaughter, which would leave all of count 2 back. So all of count 2 is viable. Does that make sense? I know you're not happy about this answer. I know this answer is not making you happy, but I'm just asking, do you understand? Right? Within count 2, this is an all or nothing proposition. So they have to check one of the 5 boxes, and if they can't check one of the 5 boxes, then all of count 2 is back. So the jury is unable to say, oh, we found not guilty as to part 2 of 2. We were found not guilty as to part 3 of 2. We found not guilty as to part 4 of 2. They can't, there's literally no way for them to do that, and the judge is not permitted to ask. So they can't find not guilty with respect to some of them, but not all of that. That is not a possible option. So unless they can check one of the 5 boxes, then the Commonwealth will be permitted to try on all of count 2, which is to say they will be able to retry the manslaughter count in its entirety. Now, whether or not they would choose to do that, of course, is a whole nother set of options. They may not choose to do that, but they can, right? They can do that. So there's no way for them to express that point of view. And the judge isn't permitted to ask. The judge can ask if she wants. She isn't required to, but she can ask with respect to counts 1, 2, and 3. She can ask for partial verdicts that way. So she can say, like, do you have a verdict as to 1? Do you have a verdict as to 2? Do you have a verdict as to 3? But she can't ask for partial verdicts within count 2. That is not permissible. And the case law, again, is fairly clear on this point, okay? So hopefully that makes sense. That is the law. That is just what the law is. I'm not here to make all your Christmases come true. I'm here to tell you the law. That is what I do. Great. All right, so fantastic. All right. Now, to make you even more mad, if you weren't already mad enough. All right, let's suppose the jury acquits on count 1 and acquits on count 3, and they check box 5 on count 2. So, we've got verdicts. We've got verdicts on 1, 2, and 3. Great. We've got not guilty on count 1, guilty on straight up non-complicated DUI, and not guilty on 3. She has been convicted of DUI. Huzzah. Okay. What can the judge consider in that when she gets to sentencing? What is she allowed to consider as part of sentencing? Is the judge allowed to, critically, is the judge allowed to consider the fact that Karen Read killed John O'Keefe? Now, mind you, they have acquitted on murder. They have acquitted on leaving the scene of the accident. They have acquitted on all the manslaughter counts, right? Because all they checked was box 5. All they said is, we, the members of the jury, found that she was driving drunk, period. Okay, right? So, can the judge consider the fact that Karen Read killed John O'Keefe when sentencing Karen Read to DUI? Can she do that? To answer that question, we turn our attention to the U.S. Supreme Court in the case of United States versus Watts, decided in 1997, that decides this exciting question in a way that will make you angry. I'm not here to make you happy. I'm just here to tell you the law. So let's consider what the U.S. Supreme Court has to say about this issue. This was a per curiam decision. In these 2 cases, 2 panels of the Court of Appeals of the Ninth Circuit held that sentencing courts could not consider conduct of the defendants' underlying charges on which they've been acquitted. So, hey, the Ninth Circuit said, you know what? We can't help noticing the defendant was acquitted on some of those charges. We can't help noticing the jury said not guilty for some of those charges. We can't help noticing those things. And we can't help noticing that the judge, when sentencing, considered facts for which the jury acquitted. We can't help noticing the judge, when sentencing, used facts for a charge the jury acquitted them of. We don't really think they should be allowed to do that. We think maybe that, if the jury acquitted, maybe the judge shouldn't be allowed to use those facts in the sentencing of other charges, because maybe that wouldn't be fair, says the Ninth Circuit. Twice they said that. That's what they had to say about the issue. What does the U.S. Supreme Court have to say? Let's carry on. Every other court of appeals had held that a sentencing court may do so if the government establishes that conduct by the preponderance of the evidence. So the Ninth Circuit's like, hey, if the jury acquits, then maybe we shouldn't be allowed to use those facts because they acquitted. And every other court of appeals that considered the issue, I'm not sure how many of them, but every other court of appeals said, no, that's okay. The jury acquitting, that's not a problem. We can totally use those facts in sentencing on the other charges. Not a problem. We can use those acquitted charges in some other thing, as long as the government proved it by preponderance. By preponderance of the evidence, that would be fine, says all the other courts of appeals. Great. The government then filed a single petition for cert seeking review of both of those cases to resolve the split. Because of the panel's holdings conflict with the clear implications of law, we grant petition and reverse. So they're like, yeah, no, we're cool with that. Then that's fine. President of the Supreme Court, they're cool with that. Yeah, we can use those acquitted charges. That's fine. Let's press on. Now, they are deciding this under statutory grounds, but if it were a constitutional issue, the statute wouldn't matter, right? If this were a constitutional problem, then they would simply say, oh, look, there's a constitutional problem. But they say, oh, this is in conflict with the statute, right? The statute seems to say it's okay. And if the statute says it's okay, we're cool because there's no constitutional issue. So it's it's totes fine. It's totes fine. The statute allows for it and the Constitution doesn't forbid it. So, we're all good, says the Supreme Court. Let's carry on. Let's learn a little bit more about this case. In the case of Watts, police discovered cocaine base in a kitchen cabinet and 2 loaded guns and ammo hidden in a bedroom closet of Watts' house. A jury convicted Watts of possessing cocaine base with intent to distribute in violation of law, but acquitted him of using a firearm in relation to the drug offense. So they're like, yeah, we find the drug violation, but we don't so much find the firearm violation. We're not cool with that, says that jury. Despite the acquittal on the firearms count, the district court found by a preponderance of the evidence that Watts had possessed guns in connection with the drug offense. So they're like, the jury may have acquitted you, but I think it's more likely than not you possessed the guns anyway. So, I'm just going to use that in sentencing. On the drug count, I'm going to use the fact that you possess guns, in the drug count. That's what I'm going to do. Because I think it's more likely than not, but the jury acquitted, but I don't care. I'm cool. In calculating the sentence, the court therefore added 2 points to as a base level, relevant to law. The Court of Appeals vacated, holding that a sentencing judge may not, under any standard of proof, rely on facts for which a defendant was acquitted, right? It's like, hey, the Ninth Circuit Court of Appeals says, hey, we don't really think it's cool that, the sentencing judge should be allowed to use facts for which the jury acquitted. That doesn't really make sense to us. So they can't do that. That's not cool with us, says the Ninth Circuit. We press on. The government argued, hold on, where was I? The government argued the district court could have enhanced the sentence without considering facts necessarily rejected by the jury's acquittal because the sentencing enhancement did not require a connection between the firearms and the predicate offense. The court rejected this argument, stating that both enhancement and the relevant law employed the connection, and held the district court impermissibly reconsidered facts the jury necessarily rejected by acquittal. The jury is the finder of fact. That's what they're supposed to be, right? And so the jury obviously didn't find that fact. If they had, they would have convicted. So they must have rejected it. So why are you considering it? That doesn't make sense to us, says the Ninth Circuit. Pressing on. All right. And then there's a second case, which, is related or is on, happening at the same time. In a different case called Putra, authorities had videotaped 2 transactions in which Putra and a co-defendant sold cocaine to a governmental informant. The indictment charged Putra with, among other things, 1 count of aiding and abetting possession with intent to distribute 1 ounce of cocaine, and a 2nd count of aiding and possessing with intent to distribute 5 ounces of cocaine, both in violation of law. The jury convicted Putra of the 1st count, but acquitted her of the 2nd. So it's like, yeah, we don't really find the 5 ounce thing. We don't really think that she possessed 5 ounces with intent to distribute. But we do think she had 1 ounce with intent to distribute. We find that. These are 2 separate events, by the way, at 2 separate times. So there's no problem there, right? These are 2 separate offenses at 2 separate times. So on date X, on date X, we find that she had 1 ounce with intent to distribute. But on date Y, we don't find that she had 5 ounces with intent to distribute. We don't find that. You know what the court would like to do? You know what they'd really like to do? We'd really like to use the fact that she possessed 5 ounces in sentencing her to the 1 ounce charge. That's what we'd really like to do. All right, so let's do that. At sentencing, however, the district court found by preponderance of the evidence that Putra had indeed been involved in that transaction with the 5 ounces. So you know how the jury just acquitted her of that exact thing? Well, not so much. The judge is like, no, I think she did it by preponderance. I'm cool. She did the 5 ounce thing. She did the 5 ounce thing. I'm cool with that. That's fine. The district court explained the second sale was relevant under relevant law and therefore calculated the offense for the other thing by aggregating the amount of both sales. So they're like, the 1 ounce thing, I think is worse because of the 5 ounces that she also possessed, for which the jury acquitted. So, 1 plus 5 is 6. So I'm going to sentence her like she had 6 ounces. Because, 1 plus 5 is 6. So I'm going to sentence her like she had 6. 6 is a nice number. How about 6? Pressing on. As in Watts, the Court of Appeals vacated and remanded, reasoning that the jury's verdict of acquittal manifested express rejection of the whole, 5 ounce thing. The Court of Appeals held that allowing an increase in Putra's sentence would be effectively punishing her for an offense for which she has been acquitted. That we don't think that's really fair. You charged her with possessing 1 ounce with intent on date X, and you charged her with possessing 5 ounces on date Y, and the jury acquitted her of the 5 ounces on date Y. And, if you sentenced her like she had it, then that would be like punishing her even though the jury acquitted. And we don't really think that's fair. We don't think you should be allowed to, sentence her for the crime for which she's acquitted. That doesn't seem fair, says the Ninth Circuit. Great, pressing on. The panel explained that it was imposing a judicial limitation on the facts the district court may consider at sentencing beyond limitations imposed by the guidelines. The then chief judge dissented, arguing the panel's sweeping language contradicts guidelines, our prior practice enhancement, decisions of the circuit, and recent authority. So the U.S. Supreme Court has been faced with this issue. Like, how do we deal with the acquittal? How do we deal with the acquittal? Should we use those facts, that the jury acquitted for? Should we use those in the sentencing of the other crime? Should we do that? Would that be okay? All right, so here's what the Supreme Court has to say about this. We begin our analysis with the relevant U.S. Code, which codifies the long-standing principle that sentencing courts have broad discretion to consider various kinds of information. No limitation shall be placed on information concerning the background, character, and conduct of a person convicted in an offense for which the court may receive and consider the purposes of sentencing. Now, again, this is what the U.S. Code authorizes, but if this were a constitutional issue, the U.S. Code wouldn't matter, right? If this were a problem because of double jeopardy, if this were a problem because of cruel and unusual punishment, if this were a problem because of a constitutional reason, we just say, oh, that's illegal under the Fifth Amendment. Oh, that's illegal under the Sixth Amendment. That's illegal under the Eighth Amendment. But it's not. So, I wonder if a statute authorizes it. Oh, it looks like it does. Oh, great. A statute authorizes it and we don't see a constitutional problem, so we all understand how this is going to go, right? We reiterated this principle in a case called Williams versus New York, in which a defendant convicted of murder and sentenced to death challenged the sentencing court's reliance on information. Defendant had been involved in 30 burglaries for which he had not been convicted. So in 1949, the U.S. Supreme Court also had a similar issue. Hey, this guy did a murder. We don't really like murder, and the jury sentenced him to death. Well, actually, it's not clear whether the jury did or not, because at this point in history, juries weren't necessarily required. Someone sentenced him to death. We're not sure who. Someone sentenced him to death. And one of the reasons they factored in is of 30 burglaries for which he had not been convicted. So, we're going to use the 30 burglaries for which he's not been convicted, and we're going to use that to enhance his sentence, and therefore death, for the crimes which he was not convicted of. The 30 burglary, but we're going to use them in 1949, right? That's what we're going to do. What does the U.S. Supreme Court have to say about this, right? We contrasted the different limitations on presentation of evidence in trial and sentencing, saying, quote, highly relevant, if not essential to the judge's selection of appropriate sentences, is possession of the fullest information possible concerning the defendant's life and characteristics. And then they also cite a case, Nichols, noting that sentencing courts have traditionally and constitutionally considered a defendant's past criminal behavior, even if no conviction resulted from that behavior. Yeah, no conviction, no problem. Citing a case, BMW versus North America versus Gore, a sentencing judge may consider past criminal behavior that did not result in a conviction. No conviction, no problem. Neither the broad language of the relevant statute nor our holding in Williams suggests any basis for the courts to invent a blanket prohibition against considering certain types of evidence at sentencing. Indeed, under the pre-guideline sentencing regime, it was well established a sentencing judge may take into account introduced at trial relating to other charges, even of which ones the defendant had been acquitted. Oh, it's well established. Oh, okay. So no charge, no problem. No conviction, no problem. You've been acquitted, not a problem. Not a problem. That's fine. Yeah, not a problem. Yeah, you can use those acquitted charges in sentencing. That's totally fine. Not a problem. The guidelines do not alter this aspect of sentencing. Very roughly speaking, relevant conduct corresponds to those actions and circumstances that court typically take into account when sentencing to the prior guidelines, as set forth. And then they cite a statute. In determining the sentencing to impose within the guidelines range or where to depart from the guidelines, the court may consider, without limitation, any information concerning background, character, and conduct. The relevant law in turn describes sweeping language the conduct of sentencing court may determine the applicable guidelines range. The commentary to the section states, conduct that is not formally charged, nor an element of the offense of conviction may enter into the determination of the guidelines range. Oh, with respect to certain offenses, such as Putra's drug conviction, the relevant law required the sentencing court to consider all acts and omissions that were part of the same course of conduct or common scheme. The relevant note explains that the application of the provision does not require the defendant to have been convicted. Oh, okay, thanks for clearing that up. The note also provides the following fun example. Where a defendant engaged in 3 drug sales, 15, 15, and 20 grams of cocaine as part of the same course of conduct or scheme, the relevant law provides the total quantity of cocaine involved is to be used in the determination of the offense level, even if the defendant is convicted of a single charge of only one of the sales. Oh, okay. Oh, I see. So they were charged with 10, 15, and 20 as 3 separate charges. 10, 15, and 20 as 3 separate charges. They were only convicted of one of them. Doesn't really matter which one. 10, 15, and 20, that equals 45. So the number's 45. Oh, that's exciting. How fun. How fun for everybody. Great, moving on. Accordingly, the guidelines conclude that relying on the entire range of conduct, regardless of the number of counts that alleged or of a convictions obtained, appears to be the most reasonable approach to the guidelines. Although Justice Stevens' dissent concedes that a district court may properly consider evidence adduced at trial that results in acquittal when choosing a particular sentence within the guideline range, it argues the court must close its eyes to acquitted conduct at earlier stages of the sentencing because broadly inclusive language is incorporated only into some section of the guidelines. This argument ignores some other part of the statute, which is we've noted, actually it's not even a statute at that point, it's guideline sentencing range, but whatever. This argument ignores some other thing, which, as we've noticed, directs sentencing courts to consider all related conduct, whether or not it resulted in conviction. We don't really care about those convictions, not important to us. Justice Stevens also contends that Congress instructed the Sentencing Commission to ensure the guidelines provides incremental punishment for a defendant who's convicted of multiple offenses. It could not meant for the guidelines to increase the sentencing based on offenses for which the defendant has been acquitted. The statute, however, is not cast in restrictive or exclusive terms. Far from limiting a sentencing court's power to consider uncharged or acquitted conduct. Yeah, uncharged or acquitted conduct, is that limited? Nah. It simply ensures that at a minimum, the guideline provides additional penalties when defendants are convicted of multiple offenses. If we accepted Justice Stevens' logic, the relevant law would prohibit a district court from considering acquitted conduct for any sentencing purpose. Yeah, no, if we agreed with this contention from Justice Stevens, it would mean we would never be allowed to use sentencing. We'd never be allowed to use acquitted conduct in sentencing. And what a mad, mad world that would be. What a mad, mad world it would be if we could never use acquitted conduct in sentencing. That would just be ludicrous. So that can't possibly be true. Whether for sentencing guidelines or for choosing a sentence within the range, a novel proposition that Justice Stevens does not defend. A novel proposition. That's how the Supreme Court feels about it. It's a completely batshit thing that Justice Stevens is just making up. In short, we are convinced a sentencing court may consider conduct of which a defendant has been acquitted. Oh, that's nice. Thanks for clarifying that. The Court of Appeals' position to the contrary not only conflicts with the implications of the guideline, but also seems to be based on erroneous views of our double jeopardy jurisprudence. You remember how that whole double jeopardy thing? Remember, you might be screaming to yourself, double jeopardy, double jeopardy, double jeopardy. You've probably been screaming at me this whole time. Oh, no. Oh, no, not double jeopardy. That's erroneous. You're erroneous. You have an erroneous understanding of double jeopardy. Tisk, tisk, tisk. Tisk, tisk, tisk. Acquittal ain't no problem, baby. The Court of Appeals asserted that when a sentencing court considers facts underlying a charge in which the jury returned a not guilty, the defendant suffers punishment for a criminal charge for which they were acquitted. As we've explained in a different case called Witt, however, sentencing enhancement do not punish a defendant for crimes for which he was not convicted, but rather increase his sentence because of the manner in which he committed the crime of conviction. In Witt, we held that a sentencing court could, consistent with double jeopardy, consider uncharged cocaine importation in proposing a sentence on marijuana charge. So yeah, no problem. Double jeopardy, not a problem. Uncharged conduct, totally not a problem. Yeah, that's fine. Totally fine, not a problem. In imposing a sentence within the statutory range without precluding defendant's subsequent prosecution for the cocaine offense. Not only, so even in the uncharged case, by the way, in the uncharged case, not only can they use the uncharged crime in sentencing you for this crime, but also, consistent with double jeopardy, they can still charge you for that crime, assuming we're otherwise within the statute of limitations. So you know how we're using the cocaine offense for which you were not even charged? You know how we're using that cocaine offense for which you're not even charged to increase your sentence for this crime? You know how we're doing that? Does that mean that we can't charge you with that cocaine offense? Silly rabbit, it doesn't mean that at all. We can still charge you for that cocaine offense and we can punish you accordingly. Great, no problem. We conclude that considering the consideration of information about defendant's character and conduct at sentencing does not result in punishment for any offense other than for the one they were convicted. Rather, defendant is punished only for the fact that the present offense was carried out in a manner that warrants the increased punishment. The Court of Appeals likewise misunderstood the preclusive effect of an acquittal, where it asserted that a jury rejects some facts where it returns a verdict of guilty. The Court of Appeals said, if the jury acquitted, that means they rejected a fact because the jury's the finder of facts, right? So it means they rejected a fact. That means they didn't find that fact. So, right, that's what it means. No, that's a silly way of looking at things. That's dumb. The Court of Appeals failed to appreciate the significance of different standards of proof that govern a trial and sentencing, stupid Court of Appeals. We explained that an acquittal on criminal charges does not prove the defendant is innocent. Oh, okay, that's great. It merely proves the existence of reasonable doubt as to guilt. Oh, okay. All right, that's nice. Oh, so an acquittal does not prove innocence. Oh, that's nice. Yeah, it just means they didn't find you guilty beyond a reasonable doubt. It doesn't mean that you're innocent, silly, silly person. That's a dumb thing to think. What are you thinking? That's dumb. As then Chief Judge Wallace pointed out in dissent in Putra, it's impossible to know why a jury found a defendant not guilty on a certain charge. Who has any idea? An acquittal is not a finding of any fact. Oh, okay. I'm glad we cleared that up, right? And you know how the jury finds facts? You know how they do that? Oh, an acquittal is not a finding of any fact. Oh, okay. I thought maybe an acquittal might be a finding of fact. Oh, no, it's not. It's not an acquittal of fact. Oh, okay. Yeah, that clears that right up. Any acquittal can only be an acknowledgement the government failed to prove an essential element of the offense beyond reasonable doubt. Without specific jury findings, no one can logically or realistically draw any factual findings. Oh, okay. Thus, contrary to the Courts of Appeal assertion in Brady, the jury cannot be said to necessarily rejected any facts when it returns a verdict of guilty. Yeah, they didn't make any findings of fact, or at least none that we're aware of. Who knows what's going on in that jury's mind? There's no findings of fact implicit in an acquittal. That's a dumb thing to think. What are you thinking? For these reasons, an acquittal of a criminal case does not preclude the government from relitigating the issue when it's presented in a subsequent action governed by a lower standard of proof, such as, for example, a sentencing, right? Such as a sentencing would be such a situation. The guideline states it's appropriate that facts relevant to sentencing be proved by preponderance of the evidence. And we've held that an application of preponderance standard at sentencing generally satisfies due process. Not a due process problem. No double jeopardy, no due process. It's all fine. It's all fine. We acknowledge the divergence of opinion among circuits as to whether, in extreme circumstances, relevant conduct that would dramatically increase the sentence must be based on clear and convincing evidence. Oh, okay. Well, maybe if it's maybe if it increases the range a lot, maybe we need clear and convincing evidence. Maybe we need that much. But, we're not going to decide that right now. That'd be silly. The cases before us today do not present such an exceptional circumstance, and we therefore do not address the issue. We therefore hold that a jury's verdict of acquittal does not prevent the sentencing court from considering conduct underlying the acquittal charge, so long as the conduct has been proven by a preponderance of the evidence, which, of course, at sentencing, is the judge alone. Right? Because in most jurisdictions, like this jurisdiction, it's the judge that does sentencing. So it's up to the judge now to make a finding of fact, as the finder of fact, by preponderance. So, geez, I don't know. What might Judge Bev do? I don't know. Geez, do you think she might find by preponderance of evidence it's more likely than not that Karen Reed killed John O'Keefe? I don't know, man. I don't know. It could go either way. Who's to say? But it's up to her. Accordingly, the Court of Appeals erred in both cases. In Putra, the jury simply found the prosecution not proved defendant's complicity in that May 9th sale beyond a reasonable doubt. The acquittal sheds no light on whether a preponderance of evidence standard established by the participation in the transaction. Likewise, in Watts, the jury acquitted the defendant of using or carrying a firearm during or in relation to a drug offense. That verdict does not preclude a finding by preponderance of the evidence the defendant did, in fact, use or carry such a weapon. I want to read that again because it's such an exciting sentence. I know you're excited. I'm excited. We're all excited, right? In Watts, the jury acquitted the defendant of using or carrying a firearm during in relation to the drug offense. That verdict does not preclude a finding by preponderance of the evidence the defendant did, in fact, use or carry such a weapon. No problem. No problem. The petition for cert is granted, the judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with its opinion. It is so ordered. Exciting. And that is from the U.S. Supreme Court in 1997, and of course, that is still good law today. So, now, for what it's worth, incidentally, by the way, the case law does preclude them from using any fact not established by a jury to increase the maximum sentencing range of the statute. So she is bound by 2.5 years. She is bound that way. She can't increase the sentencing range of the statute. She can't do that. And also, incidentally, by the way, for what it's worth, there, of course, could be some Massachusetts state law that precludes this. So just in case there's an issue with, this coming up later, right? There might be some law in Massachusetts by the, Massachusetts statutes, or there might be a Supreme Court decision from the state of Massachusetts. There might be some state law that says you can't do this. So I don't know whether or not that law exists, but I can tell you it's not forbidden by the federal law. So assuming arguendo that there is no law that precludes her from doing this on the state level, she can. And assuming she finds by preponderance of evidence that Karen Read killed John O'Keefe with her car, at 34 Fairview, assuming she finds that by preponderance of the evidence, she can use that factor in crafting an appropriate sentence. So she may somewhat depart from the guidelines range in the state guidelines. The guidelines, as we looked up earlier today, assuming I understood them properly, recommends no criminal punishment. It recommends only what they called intermediate sentencing, or whatever the fuck that is, right? Basically probation kind of stuff, right? So the guidelines seem to recommend things like, maybe a drug class or an alcohol class, maybe some probation stuff, maybe that kind of thing, right? That's what the guidelines range is. But of course, guidelines are guidelines. The guidelines are guidelines. And assuming that, the law otherwise allows for it, which, maybe there's some restriction, and we can get into whether or not there's a restriction on the state level. But assuming there is no restriction on the state level, the guidelines are, of course, guidelines. And she could depart from those guidelines up to the maximum of the statute. And the only thing that would be stopping her at that point would be an abuse of discretion analysis, from a future court of appeals. So, long story short, in the absence of any state law to the contrary, Judge Bev can almost certainly will sentence her to the 2.5-year max that is allowed by law, because she can use the fact that she killed John O'Keefe as part of that sentencing as far as the federal law is concerned. The U.S. Supreme Court has no problem with this. They're totes cool. And so, that 2.5-year sentencing is looking more and more likely with every passing moment. Great. So I'm glad I could clarify all those things for you and make you just super duper happy. Tell your friends about this exciting news. I'm sure they'll learn to love about it. All right, someone cited a state case, so we'll go read it. Commonwealth versus McCravy disallows this. So we're going to go see whether or not that's true. So maybe she'll be saved by the state law. So we'll go look it up and see whether or not she's saved. We'll go look it up. Josh H for $5 says, if Bev sentences the max, I can see the Reed case being primed to revisit the prior opinion. Well, there's been many calls at the U.S. Supreme Court to revise this. I don't know whether or not the Reed case would be a basis to revise this. But there are other cases. But Jose Guzman says there is a state Supreme Court case that precludes this. So we will, of course, do our due diligence and see whether or not she is going to be saved by state level law. So let us do that and see whether or not state law will come to the rescue. Maybe it will be good news after all, and you can become less depressed. But at least you've learned something about federal law along the way. So even if the state law precludes it, at least you've learned something about what the federal law allows for. So, hey, it wasn't a completely wasted exercise. Let's see. I want to do Massachusetts courts, and I want, thanks for encouraging your interest in law. No problem. I'm here to help. What did I do wrong, and how do I fix it? Okay, let's see. Massachusetts, there's got to be a button somewhere that says, okay, done. That's what I was supposed to do. Okay, type this case. Okay. Let us turn our attention to this case and see whether or not this will save Miss Reed. We turn our attention to the Supreme Judicial Court of Massachusetts in the case of Commonwealth versus McCravy. We'll see whether or not this case will save Miss Reed. Will it help her? Let's find out. Of course, incidentally, by the way, of course, the Supreme Court could always change its mind. So maybe this case, assuming, maybe they'll think, maybe we should revisit that and resentence her. Yeah, well, let's see what the law is as of today. Yeah, maybe we'll revisit this one for Miss Reed. Who knows? We'll see. All right, let's see what we got. This matter is before us on defendant's appeal from his conviction of driving negligently or recklessly so as to endanger the safety of the public. We transfer the case to our court on our own motion. He claims error in 3 respects. Okay, first, he contends the Commonwealth impermissibly presented to the grand jury the same evidence that already been found insufficient by a prior grand jury. Second, he challenges certain remarks of the prosecutor. Finally, he argues the sentence imposed by a trial court was unlawful because it took into account the death of a passenger in the car the defendant was driving on a homicide for which the jury has been found not responsible. All right, so argument number 3 is definitely the one we want. So let us see what argument number 3 is on this point. Let us see. All right, let's see. So that looks like here. Great. So what does the Supreme Judicial Court have to say about this issue? At sentencing, the judge stated several times he was considering the sentence in light of the fact that death was involved among other factors. Defendant argues it is unlawful for the judge to take Archibald's death into consideration when he had been acquitted of the homicide-related indictment. The Commonwealth responds the sentence was lawful because the judge merely took into account the consequences of defendant's conduct. It suggests the judge properly could consider the possibility the jury may have determined the defense actions were not the proximate cause of death, but did contribute to it. The sentence imposed by the judge concerned only the defendant's conviction for operating negligently to endanger. The maximum sentence for a first offense of imprisonment is 2 years. Defendant was sentenced to a term of 1 year in house correction with 6 months to be served and the balance suspended. The sentence is well within this permissible statutory limit. It's not within our power to review a lawful sentence. How is it not within your authority to determine a lawful sentence? That seems like the weirdest thing I've ever read in my life. But okay. It's not within our power to review a lawful sentence. That authority is delegated to the appellate division of the Superior Court. Where it appears, however, a defendant was sentenced for a crime other than for which he's been convicted, it's within our power to review the sentence. Oh, okay. Defendant argues the difference between motor vehicle homicide while operating recklessly or negligently, a crime for which the defendant was acquitted, and negligently or recklessly operating a motor vehicle so as to endanger the safety of the public is cause of death. Well, yeah, presumably among other factors. The judge stated that prohibition was normal sense in the case of the latter. The judge had earlier stated that the person who was operating a motor vehicle so as to endanger the lives and safety of the public is responsible for the fatality, and based on the defendant's driving record and Archibald's death, there was no alternative but to sentence the defendant to a term of incarceration. It appears to us from these statements, the judge may have sentenced the defendant more harshly than he otherwise would have because he believed the defendant's action caused the death of Daniel Archibald. In order to clarify whether the judge sentenced the defendant more severely because he held responsible for Archibald's death, we remand for resentencing solely on the charge for which the defendant was convicted. So this language does appear to preclude it. I tend to agree with your reading. So I do tend to agree with you that it looks like you cannot use any charges for which they were acquitted in sentencing. So it appears that she can only use the DUI unto itself. And so I guess we're back just into the statutory guidelines of, how about the intermediate sentence thing with, the probation-like sentences or the probation-like stuff. So it does appear to preclude it, although the language I would like to be a little bit clearer, but it does appear to preclude it. So yeah, it does seem to suggest that. So it looks like that's funny. It looks like the Massachusetts Supreme Court may come to her rescue, even though the U.S. Supreme Court will not. And which is, of course, is completely valid. It's completely valid. States can always offer more rights. They can't offer less, but they can always offer more. So that's something Massachusetts can absolutely do, and appears to be something they've done. So assuming that this case has not been overturned, and I'd have to go, do case law research to see whether it's been overturned. I'm not sure what the easiest way to go about doing that, but assuming it's not overturned, then, that seems like a good thing. Let's see if I can find out real fast whether or not the case has been overturned. I'm not even sure whether or not I can do that, but let's see if I can find out. Give me a second. Because I'm interested, because I'm here for it. Give me one moment, please. Let's see now. All right. But in any event, once again, you've learned something about federal law. So that's, always good. So you've learned something about two kinds of law. And that's always a valuable exercise. Now let's see. Let's see if I can find it real fast. Okay, Fastcase does not want to load for me, so I'm having a bad day. I can't load Fastcase for some reason. Fastcase does not want to load for me today. Oh, maybe it's because I blocked the web page or something stupid like that. Let's see if this helps. No, not really. All right, we'll ask ChatGPT. ChatGPT will ask, whether or not it's been overruled. Has been overruled. When in doubt, ask ChatGPT. ChatGPT to the rescue. Has not been overruled. All right, great. So we'll go with that. So it remains good law for the moment. Excellent. So yeah, it looks like her probation-like sentencing is back on the menu, boys. What did I do? Why is Kestrel yelling at me in chat? What did I do? Why are you yelling at me? Like a modern lawyer? Well, Fastcase wouldn't load. I was going to look it up in my legal database, but it won't load. So, I did the best thing I could do in that situation because I couldn't get it to load. What do you want from me? Anything else I can talk about while we're here? Has the jury announced a verdict? No, of course not. If they had announced a verdict, we'd be having a completely different discussion. Someone log into Westlaw? Yeah, that'd be nice. I mean, it's quick and dirty, but what can you do? Because Fastcase does not want to load for me from the Virginia State Bar website for some reason. Maybe if I load it in Chrome. What's my vote on the verdict? Not guilty. 100%. Not guilty 100%. On the DUI charge itself, I'd probably vote guilty on the DUI charge. I wouldn't go out of my way to do it, because I'm kind of pissed. And the rule, the judge's charge doesn't require me to, right? The judge's charge said if you do not find it, you must acquit. But if you do find it, you should convict. So the rules don't require me to convict. So I wouldn't go out of my way to do it. But if it would help move things along, if it would help move things along, I would vote to convict on the DUI. There's sufficient information to convict based on what's available on the record. Yeah, there's sufficient information available to reach beyond a reasonable doubt. So that's what I would do in that case. She's fooling all of us. She may well be. Well, no, that's not the problem, right? As I keep trying to remind people, right? The issue isn't whether or not she's fooled us or not. That's not the issue, right? It isn't even what it's like. This is why it's important to remember the question. The question is not did Karen Reed kill John O'Keefe? That's actually not the question. The question is more precise than that. The question is, has the state proven each and every element of the charge, right? So whether or not she killed John O'Keefe is not exactly the question, right? So like, it's whether or not the state has proven it. So it has nothing to do with fooling me. It has nothing to do with fooling me. It has to do with whether the state proved it. That's it. That's the game. That is the game. So it has nothing to do with her fooling me. It has to do with whether the state has proven it. In my judgment, no. They have not proven each and every element of the offense. So therefore, not guilty. It's that simple. The state must prove by preponderance of the evidence. No, they have to prove guilt beyond a reasonable doubt. With respect to guilt, with respect to sentencing for things beyond, they can't use the acquitted stuff apparently, but anything else they wanted to use. Not that I think there is anything. So I don't know what else they would try to bring into the equation. But if they wanted to bring other things into sentencing, then presumably preponderance would be correct. For other things they want to bring into sentencing, that would be correct. But not for the underlying guilt phase, no. How can anyone be convicted of DUI or OUI if not tested at the scene? Yeah, I don't quite understand this question. I don't really get this question on some level. This is a strange question to me. Like, this is a strange question. How can anyone be convicted of DUI if I've heard this question asked a couple different ways. Like, how can anyone be convicted of DUI, charged with DUI if they weren't charged that night? The same way they can be charged with any other crime. You're like, what? There is no crime for which you have to be charged the same day it happened. There's no crime for which there's no crime for which the government needs evidence they collected the day it happened. That doesn't make any sense. DUI is just like any other crime. They need evidence to convince a jury beyond a reasonable doubt. That evidence does not need to happen on the day in question. That's how it usually happens, but it doesn't need to happen that way. Right? That's the same for any other crime. You wouldn't ask this question about any other crime. Right? You wouldn't ask, well, do they have like evidence they collected that day or that night? Did they charge her that day or that night? You wouldn't ask that question for any other crime. So why does it make sense to ask it for DUI? It doesn't make sense, right? They can charge DUI, anytime within the statute of limitations. And what they need is evidence to prove it beyond a reasonable doubt from wherever that evidence may come. So that's how. It's kind of the same way they would any other offense. Obviously having a breathalyzer or a blood draw, like right then and there would be really helpful, but it's not required. So I find the question slightly strange. I think people are confusing the way it usually happens with the way it must happen. Like 99.9% of the time, yeah, like DUI probably is based on a breathalyzer. They did that when it happened. Yeah, 99.9% of the time, DUI is based on a breathalyzer they did or a blood draw they did, like at the time of the offense. That's true like 999 times out of 1,000. But it doesn't need to be true. Just because it's usually true just because it is sufficient does not mean it's required, right? A breathalyzer might be sufficient. A blood draw might be sufficient, but it's not necessary. So the question strikes me slightly strangely, but yes, that's how. The same way they'd prove any other crime by bringing together sufficient evidence to prove the offense, however they can get it. Yeah. 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 People are just confusing the way it happens 999 times out of 1,000, because I'm sure it does. I'm sure 999 times out of 1,000 it does happen because of a breathalyzer or a blood draw that happened essentially contemporaneously. I'm sure that's true 999 times out of 1,000. But just because it happens that way 999 times out of 1,000 doesn't mean it has to be that. Doesn't mean it has to be true. So yeah, that's the confusion. In Pennsylvania, the DUI, they need to test for hours. The only exception is the driver refuses. I find that very difficult to believe. So fucking awesome, AKA Rob. So let me get this straight. let me make sure that I completely understand this. You're trying to tell me that in Pennsylvania, if the police, like a week after the event, so a week after the event, the police are, scrolling Facebook as they do, and they see a guy who has a dash cam of himself. He has a video of himself, chugging the liquor bottle as he's driving down the street, weaving, on the road, slurring his words, nodding off and all the rest of it, the whole 9 yards, right? Right. And he's taken video of himself because of course he has. And you're telling me that in Pennsylvania, they cannot charge DUI because they didn't do a breathalyzer within 4 hours of whatever? That can't possibly be true. There's no way that that's true. That doesn't make any sense, right? Also, by the way, there was a person in the car with them. Also, there were 3 people in the car with him who were there to testify about his drinking the entire evening. He was driving a goddamn 15-passenger van. There are 14 other people in the car, all of whom were with him the entire evening and could testify in laborious detail about his drinking, in excruciating detail. Plus, they all have video of him drinking the entire evening. Plus, he has dash cam of himself he recorded. And you're trying to tell me in Pennsylvania they can't charge DUI? Bullshit. Bullshit. No way that's true. So you're saying if I hit something or someone, drove home, and the next day the cops come to my house, they can convict you of DUI? Based on that, no. There's not sufficient information in your hypothetical. They could charge you with leaving the scene of the accident. That's what they could charge you with based on that hypothetical. There's insufficient information to show that you were drinking based on that. No. Yeah, it's not true. I just looked it up. Yeah, it's like it can't possibly be true. There's no way that can be true. Pennsylvania is not that dumb. Pennsylvania did not write a statute saying, oh, you must do a breathalyzer. There's no fucking way they wrote that statute. Pennsylvania is not that stupid. There's no fucking way they wrote that statute, right? Yeah. Yeah. But isn't that what they're saying Karen did? No, they have more information than that. They have video. They have more information than that. They have they have video of Karen at the bar in which they've attempted to count drinks. They have eyewitnesses at the bar who've attempted to talk about her alcohol. And they have Karen Reed's own statements relating to the various things they do. They have more information than that. Yeah, they have more information to be able to charge DUI. Never underestimate the stupidity of the legislature. Fair. Maybe Pennsylvania did it dumb, but probably not. They're probably not that dumb. Has there been a verdict? No. If there had been a verdict, we'd be having a much different discussion. You can refuse and get your license suspended. Yes, that's pretty typical. Implied consent is pretty typical. Yes, that's the law in most states, I think. Yeah, if you refuse, they will suspend your license as a matter of course. That's true. Yeah. And they may still be able to charge you with DUI depending on what else they have. Right? So if you refuse the breathalyzer, you refuse the blood draw, and they're unable to do it, they might still be able to charge you with DUI based on other information that's available. Depending on what's available, they might be able to do it anyway. So you might get your automatic suspension and still be charged with DUI. So yeah. I'm back, baby. You know it. Easier to appeal and win with a DUI conviction? Not really. I don't think it's any easier or harder to appeal on the DUI conviction. Well, it might be harder. I'm not sure it's any harder legally. It might be slightly harder practically, because to the extent the Court of Appeals was going to care, they're probably going to care a little bit less about a DUI, just because, it's not as serious. And they're human beings too. So they're probably, yeah. But legally, I don't think they're any better off. I think they have basically the same issues. Well, they might have, I don't know, they might not have as many issues for conviction on DUI. I'd have to really think about it, but yeah, they might be worse off. They're no better off, and they might be worse off. They might not have as many things to work from, because you'd have to show, like, basically essentially prejudice with respect to the DUI conviction, which would be a little bit harder. So a lot of the testimony becomes irrelevant to that, and so kind of gets blotted out of existence. And so you can't really raise those issues, because they don't really. You'd have to, it doesn't really work. I hope we get a verdict tomorrow too, man. I really do. That'd be great. It's not clear that they have Friday off. I've heard conflicting things on whether or not they have Friday off. I'm not sure. I've heard conflicting information. They have Thursday off, but I'm not sure about Friday. So I'm not 100% on that one. You still appeal? Fair enough. I understand. Yeah, I understand. But, depending on, especially if people are right in what they're saying, and this case we're reading looks correct. So if she's only sentenced to effectively probation-like penalties, if that's all she's sentenced to, which based on the guidelines, it looks like it was, if I understood the guidelines correctly. So she can only be sentenced to these probation-like penalties. Maybe they don't appeal because maybe they just don't care enough to appeal. But, maybe they do, maybe they don't. I can't speak to that issue. If she doesn't get any jail time, then, yeah, maybe they don't appeal. Yeah, I think there might be a court on Friday. No court on Thursday, but court on Friday, I think, is correct. Yeah, I'm getting conflicting information about whether there's court on Friday or not. Not sure on that one. I guess we'll find out one way or another pretty soon. If there's no court on Friday, the probability of them, reaching a conclusion by Wednesday would go up substantially. So yeah, if there's no court on Friday, the probability of a verdict by the end of Wednesday goes up pretty dramatically. Yeah, courts are open Friday according to the calendar. There you go. Yeah, so then I wouldn't necessarily think that Thursday off would put any pressure on them. Although, still one day. It's better than nothing. How will the verdict impact the civil case? It doesn't really. Doesn't really impact it much either way. Bev may not be open on Friday. Fair point. Yeah, the courts could be open on Friday, but maybe Bev is not open on Friday. Fair point. Maybe Bev is not taking cases. Maybe Bev wants maybe she wants her, what was that be, 4-day weekend at that point? Yeah, fair enough. Fair enough. Am I doing okay? Other than the fact that my eyes are attacking me at the moment with allergies and or light sensitivity, yes. So I think I'm having an allergic reaction to light at the moment, which sometimes happens. But other than that, yes, I'm doing fine. Yeah, the light sometimes gets to me. My eyes are a bit sensitive to light, so sometimes it gets to me a little bit. No, I wasn't on with Melanie today. it didn't really happen. I texted her, but she didn't text me back. I assume because she was too busy, which is fair enough, you know. Yeah, so it didn't happen today. No, the FBI can investigate violations of any federal crime. In this case, they were investigating possible corruption issues that might comprise a violation of Karen Read's civil rights. It seems they were looking at 18 U.S.C. 241 or 243, presumably. Do I have any preservative eye drops? I've never been able to use eye drops. I've never been able to use them successfully. My eyes, I just can't do it. I've never been able to use eye drops. So, we suffer on. I have never, ever been able to use eye drops. Yeah. I can't seem to get the eye drops in my eyes correctly. It's a whole mess. It's a whole thing. It's a pain in the ass. I should get on with Defense Diaries if I'm invited. I sent them a DM today, but I didn't hear back from them either. So if I'm invited, I might drop on with them tomorrow too. Allergy shots? Maybe. Right now I'm just taking Claritin and nasal spray at the same time. I'm taking Flonase and Claritin. So see if that works, but that's what I'm doing at the moment. But I'm not sure there's any allergy shot that would help me for what I'm having right now. If I'm having an if I'm having an allergic reaction to light, which I think I might be, I don't think there's an allergy shot for that. So I might be out of luck. Claritin D. I don't have congestion, so Claritin D would be overkill. Sunglasses? I could wear sunglasses. Then at least you wouldn't have to look at me anymore. Yeah. Yeah. Now I look cool. Now I look good. Now I look badass. I wear my sunglasses at night. Da, 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 da. Need a hat with those glasses? Yeah, there are definitely people who don't understand what evidence is, which is funny to me because we sort of when I was doing the hypothetical yesterday with you're in a liquor store and you see this guy, drink a bottle of vodka and get on the road and drive. It's like, oh, it's your word versus their word. There's no evidence. I'm like, you don't understand what evidence is. Eyewitness testimony is definitely evidence. I promise you, it is 100% evidence. Whether it convinces the jury or not is up to them, but it is definitely evidence. That's silly. It's not an eye infection issue. I've had light sensitivity problems for years. It doesn't normally bother me every time, but every once in a while my eyes get a little bit, every once in a while with the light shining right in my eyes because I have a light box shining right in my eyes. Every once in a while, and I've been streaming all day, so my eyes are very fatigued. I've been streaming with a light box in my eyes all day long. So, I'm not particularly surprised that my eyes are acting up at this point because it's a lot. It is not an infection issue. My eyes are just sensitive to light. It's a problem. Evidence, Lucky's testimony is 100% evidence. Of course it is. Of course Lucky's testimony is evidence. I'm sure 100%. I thought it was acute. Well, I guess light. I don't know. I suppose it is acute, but acute doesn't acute just mean it's persistent? Uh, acute conditions are severe and sudden. Okay, in that case, it's not acute. Yeah, never mind. It's 10 o'clock. It is, in fact, 10 o'clock. That's true. Yeah, chronic. You're right. Chronic is the opposite of acute. Right. It's chronic then. Yep. I had it backwards. Yep. Chronic, not acute. Yep. That's right. Uncivil made a mistake. Uncivil made a vocab mistake. I know it happens sometimes. I made a mistake on a medical term. I got it backwards. Please forgive me, chat. I apologize for the error. Words are hard sometimes. Uncivil makes mistakes. I even make legal mistakes sometimes. I get the law wrong, or I don't know something. Like I didn't know about the Massachusetts Supreme Court case until just now. You know? So sometimes I don't know everything. I'm learning things all the time. Yeah. Photophobia glasses that are for light sensitivity, like the ones that Emily D. Baker has. Maybe. I don't know if that would be a good look for me or not. Should I get like the glasses that Emily D. Baker has? Hmm. Theraspectrix. Okay. All right. Theraspectrix. Light lenses are designed to filter wavelengths to help with all types of problematic light. Okay. So I want the pro ones, I guess. Strongest protection for artificial light and digital sensitive screens. I don't know, man. 120 bucks. That's not so bad. Then I just have to figure out which ones of glasses to get my face. I don't know that that's a good look for me. I don't know about those glasses. I don't know, man. That's weird. Hmm. All right. Which ones do I get, I guess? Let's shop for lights together. Let's shop for glasses for uncivil. All right, let's take a look at this. These rose-colored glasses use filter to prevent wavelengths, making perfect defense if your eyes are sensitive to light. Okay. What? Which ones do I get? Um, Pilot Therospecs. I don't know about that. Falco Therospecs. That no. Rap Therospec. Maybe Raps. Yeah, maybe that's one. Maybe those are the ones for me. Hmm. Rose color? Yeah, apparently. Lens strength, standard, extra, or max? Best choice for remote people, Docker or more protective? Probably standard, right? Max feels like a lot. Extra? I don't know. Standard? I don't know. Ask the ladies. $129? Maybe. Maybe that's the answer to my needs. The wraps are probably for me. 60-day return. That's not bad. It helps choosing a lens. Lens assistant chat. Okay. Let's do a bot thing. Hi, I'm the assistant. I'll help you. To get started, what's the primary reason you're considering it? Light sensitivity. Indoors, I guess. Is there a specific type of indoor light you found most challenging for your light sensitivity? Not really. No. I return a lot of stuff I buy? Not really. I don't return a lot of stuff I buy. What makes you think that? What specific symptoms do you experience with your light sensitivity? Eye pain, allergic type reaction. The Conrad ones. Let's take a look at those in a second. How would you rate the impact of indoor light sensitivity on your eye pain? Moderate, I guess. Yeah, conviction would take away our Second Amendment rights. That's correct. Yeah. So the conviction on DUI would take away our Second Amendment rights. That's true. Whatever value it has. The bot apparently has given up on me. Hello? The bot has given up. The bot no longer wants to help me. I've broken the bot. No. No. Well, that was annoying. I'm sorry, I couldn't find a recommendation. Great, thanks. That's super. The bot has given up on me. Moderate. Based on your answers, I recommend our standard strength PL Pro lens. Okay. All right. Or perhaps our standard strength blend if you prefer more salt that provides a little less protection. The Pro is fine. So let's see. Amazon Dream Glaze would look good. Conrad? Is Conrad a style of glasses? I don't see Conrad. I think wraps are probably my style. Wraps feel like me. I think the wraps feel like me. In a standard, could be good. Conrad Theraspex. Okay, let me Google and see if I can, because I'm having trouble seeing it. Conrad Theraspex. Oh, okay, I see. You think those are better than me? You think those are better than the wraps? I don't know. What do you guys think? Not sure they're my taste. Yeah, I think the wraps are my taste. Yeah, I think the wraps work. I'm feeling the wraps. All right, maybe I'll get these. Maybe I'll get these ones, and then I can have these glasses, and they'll be interesting for streaming. Emily D. Baker uses Irwin lenses. Okay, let's take a look at those. See if those are the answers to my problem. Let's take a look at this other brand, the one Emily D. Baker uses. Let's see if that's the answer to my problems. Irwin lenses. Okay. Light sensitivity. Okay. All right. So let's see. How much are these glasses? Shop our store. All right. Let's see what we got. Uh, get tested. Do I have to get tested to get these lenses? They're prescription and expensive. So I have to get tested for this. How much are they? They're expensive as fuck. How expensive is expensive as fuck? When they don't tell you the price, it's not really a good stand. It's not really a good good thing. A lot. How much? Initial screening from $100 to $250. Okay. The lenses and frames are $450 to $600. Oh dear. Yeah, that's pretty expensive. So it's going to cost me like $600 or $700 to do that. Yeah, that's pretty expensive. Look up locks, 400% UV protection. Well, UV isn't what I need protection from. So that's not my issue. I need and if how's that better than what I'm already wearing? You know, in terms of UV protection, these already have UV protection. So yeah. What proof of Karen Reed driving under influence was presented? Again, her drinking at the bar. They counted drinks at the bar. The videotapes of her drinking, they counted them. Also, the blood draw done by the hospital. That would be evidence, for example. Emily D. Baker is rich. She is rich. She is Emily D. Baker money. I do not. All right. I think the Theraspex wraps might be for me for 120 bucks, 129 bucks. 129 bucks is much more my price point. Maybe I'll get these. I'll think about it. I can have them in 1 to 3 business days. All right. Well, maybe I'll pick those up. I'll think about it. If you have other recommendations for other brands I should be looking at or something, then feel free to drop a note on my Discord. Let me know if there's other brands I should be looking at or things I should be considering, but this is pretty good. Take advice from the professionals. Well, how do I know who the professionals are? The professionals are the same as they look the same as anyone else. I won't get them. I might get them. I might get them. I'm just, I want to see what alternatives there are. If I could get the same thing for less, or then I'm interested in that too. How am I doing? Pretty well, all things considered. Get your eyes tested. So pay the fee for like the ear one. Pay the fee for those testing. I mean, I could do that maybe. FL41 lenses. Okay, let's take a look at that. Amazon has a variety of brands under $40. Yeah, but are any of them any good? All right, these F140 lens. Let's take a look at this from Amazon. Warby Parker. Okay. See, we got FL41 rose and outdoor tinted lenses. Okay. So these look really similar. Okay. Is there any style here I like? I'm not sure if I like any of these styles. These ones are interesting. Safety glasses, interesting. FL41 bifocal reading glasses for light sensitivity. Those are interesting. $16. That's not bad for safety glasses. That's kind of good. Yeah, that's kind of good. Yeah, I could get that for $16. If that solves my problem, that's not a bad deal at all. And I want no magnification. So 0 magnification. That's good. Okay. Yeah, that's cool. Did they make them in a wrap style on Amazon? Yeah, they kind of do. Oh, they have these ones. This looks cool. Those look cool. I like those. Those are neat. All right, cool. All right, Rebecca, you're not being helpful. You can get banned. All right, cool. Maybe I'll pick up one or both of those. That's cool. I'll take a look at it in the morning and see what one looks good. But I appreciate this recommendations. Those are very nice. So and I actually buy the thermospecs right from here for 119 bucks too. I can buy the thermospecs for $119 right from Amazon too. Oh, okay. So I guess the question is, what is the difference between the thermospecs and the cheaper ones? I guess what is the practical difference other than like $100 basically? I mean, they might be better for all I know. I don't know if they're $100 better, but there's something. Well, I'll add those to the cart too, and I'll look at that in the morning and try to make a decision. All right, cool. Look at the reviews. We'll do. All right, I'm going to sign off for now. Thanks for all those recommendations. I'm going to sign up for now. I will see you tomorrow. I'm going to send you the stream for tomorrow, so make sure to give it a like while you're there. And I'm going to go to bed and get some sleep. So I will see you mañana. Until then, my friends, I hope all is well. Cheers, my friends, for now.